Okay, hello. This is the second. I'm actually going to combine the rest of these cases and materials on Title VII law into this one lecture, so it might be a little long. It might run about 30 minutes because we're going to cover actually 3 cases. Um, so let me share screen. We left off with the Sears case where we saw that the idea that women have different sort of cultural preferences, culturally conditioned ways of being in the world and ways of relating to the workplace was used, talked about, invoked to justify a gender division of labor at the Sears retail level where more men worked on commission and made more money and more women worked on non-commission sales and made somewhat less money. The case was entirely statistical. The case developed into a case in which the Reagan administration inherited, responsibility for prosecuting the case, and the leaders at the EEOC don't like disparate impact analysis. And by the way, there are good reasons from a conservative point of view not to like disparate impact analysis. One argument is that the ability of plaintiffs to get into court based on statistics provides an incentive to employers to use a sort of a sense of proportional representation in their hiring in relation to the qualified workforce, right? So it's actually an incentive to affirmative action or group quotas, whatever the language is. The counter argument to that, though, is that disparate impact analysis is a device that's rationalizing in the good sense of the word rationalizing. In other words, making more rational. That is, if you have criteria and they actually have a disparate negative burden on traditionally disadvantaged groups, you should justify those criteria as related to the job, right? So it's not like you can't have them, but you have a burden to meet. How this actually plays out in practice, it's very difficult to bring these cases. You need resources. Most cases don't get brought. Most cases that get brought get settled, usually on terms favorable to the people with the money and power. So, it's all very complicated. And we can't really delve into the details of how this actually plays out institutionally. But we can look at, the play of ideas and law and think about some of these issues at the interface between legal norms and legal institutions, and in this case, women in work. So I'm going to share the screen, and we're going to go to the PowerPoint. So the next case is different. It fits more comfortably within an idea of feminism as treat women the same as men, because women are the same as men. It's a different kind of case, a different kind of dynamic. Johnson Controls is a manufacturer of batteries for automobiles, like the batteries that go in cars. And this factory is located in Vermont. And in producing this product, exposure to lead is inevitable. You can't eliminate all exposure to lead and still have an economically viable business. So this work entails some health risk. Before 1964, the court tells us this is a Supreme Court case, a 1991 Supreme Court case, and it's a landmark in this area. Johnson Controls doesn't employ any women at all, right? And after Title VII, it starts employing women in these manufacturing jobs. When women begin working to the areas of the plant, of the factory that involve exposure to lead, Johnson Controls policy for a good time in the 70s is a warning to everybody. Look, this work entails some risks, and we know that exposure to lead includes risk to reproductive health. There could be harm to an unborn, to the unborn. So, beware, but you can assume that risk if you choose to. Why would you want to? Well, you get more pay. So it's a desirable thing. In 1982, and, looking back with the benefit of hindsight, the timing is interesting. It's the Reagan era. It's a more conservative era. There's sort of pushback, backlash, in one author's phrase, against the feminist movement. And there's this case is a part of a whole range of what were known as fetal protection policies and ideologies. And this took place at other workplaces where fetal protection became important. It bled over into the criminal law with prosecutions of pregnant women for transmitting drugs to their unborn, right, through the body. That was part of it, and a whole range of other aspects of this fetal protection effort. But in 1982, the company changes its policies, and it now says that women who are either pregnant or capable of becoming pregnant can't work in this part of the factory. So to keep these jobs, a woman would have to show that she could not become pregnant. A woman of childbearing age would have to show proof of sterilization. And you think, well, no one would do that to keep a job, but actually a number of women did do that at other companies. American Cyanamid, this company, did this to keep these jobs. So that's the policy, right? And the company says, well, we had to change the policy because we learned that many women had become pregnant while working in this part of the plant. We're protecting the unborn, and we're protecting ourselves from liability, potentially catastrophic legal liability. That's our position, right? So that's the policy. In 1984, the union representing the workers, the United Auto Workers, sues the company, claiming that this policy violates Title VII of the Civil Rights Act. So that sets up the issue in the case. And you might want to pause here for a minute and say, all right, so what are the arguments? Like, if you're the plaintiff in this case, what are the arguments? And again, we're looking at how legal doctrine and statutes and prior decided cases, especially in this case, Griggs v. Duke Power, structures the logic of the argument, constrains it, channels it, opens up opportunities for development and movement, but it's a particular kind of conversation. So you have to fit your argument within the terms given from Griggs, and you have two kinds of cases. You can allege intentional discrimination and prove it, and then the employer, if you prove intentional discrimination, and you have the burden of proof on that issue, the employer can only then say BFOQ for sex, that sex is a bona fide occupational qualification. If it is not intentional discrimination, then your other option is a disparate impact case, and obviously there's a disparate impact. So then what can the employer say? Well, the requirement's job related. Well, here, obviously not, right? That job related is, can you do the job, and capable of becoming pregnant, doesn't affect whether you can do the factory work. But then there's this other idea of business necessity, that it's actually a threat not to have the standard here. Women can't work in this part of the factory that exposes them to lead. Not to have the standard exposes you to liability, and might throw in, our motives are good, benign, noble. We are saying we're protecting the unborn, but we also are protecting ourselves from, again, catastrophic legal liability. What are you arguing if you're the plaintiff? I mean, where do you want this case to be fought out? How would the arguments work, right? So you can run both kinds of arguments, and of course, impact is a piece of evidence for intent, right? So I've just sort of gone over Johnson Control's arguments, right? It's not intentional discrimination because the motive or purpose isn't animosity, isn't to harm women. The lower courts accept that claim. They accept that it's not intentional discrimination because of the benign motive and purpose. And then it's a disparate impact case. And lower courts also buy the business necessity argument. So it's unfortunate, but there is this defense, and it's accepted. So in the lower courts, Johnson Controls can keep this policy. When it goes up to the Supreme Court and they take it, there's only one woman on the court at this time, Sandra Day O'Connor, in a landmark 9-0 decision. So there's some conservative people on this court. Scalia is on this court. Rehnquist is on this court. The Supreme Court holds that the lower court got it wrong. This is clearly intentional discrimination, and we're not really looking at motive or purpose. We also look on the face of the law, and the law says women are excluded and men are not. right? And women can become pregnant and men can't, so women are excluded. But the question really is, if you put it properly, is are men and women similarly situated with respect to health risks and this labor? And the answer is pretty much mostly yes. Um, you know, last we checked, men are involved in the reproductive process, and there's expert testimony that lead can be transmitted through sperm, and it can have the unlikely but devastating effects of causing severe birth defects. So if men are told there's a risk and you can take it, and women are told there's a risk and we paternalistically decide you may not take it, men and women, similarly situated men and women, are not being treated alike, and that's facial intentional sex discrimination. Okay? Okay, now Johnson Controls has a different burden, and it's the BFOQ burden. And it can't meet it because there's no way that it's a BFOQ. The court says very explicitly, BFOQ is the ability to do the work. Now, to me, this is interesting because one finds a lot of cases in the lower courts, as we saw last time, that, you know, sometimes cultural conventions about gender and the workplace aren't just whether you can physically do the job. It's about understandings and appropriateness, right? Women in maximum security male prisons, male nurses' aides in women's space in private nursing homes, you know, and so on. But that's the claim here is you don't have a BFOQ. That's the result. The union wins, and it's a basic equality proposition. And you always want to watch out with equality arguments. You know, this, some might say, okay, women have won the right to be treated equally badly. Is it a victory? You're an individual choosing self just like a man, and you can make the choice. I don't know. Most would say that it is a victory, that equal treatment as same treatment is a valuable thing, even if it's not ideal. We could complicate it. Like, what if the next case involves a woman who wants to become pregnant, who's working there, has chosen to assume the risk, but then wants to intentionally conceive? Does the employer have to make an accommodation for her reproductive choice by, you know, giving her a job somewhere else in the factory, or holding that job for her until she's not going to be becoming pregnant? Would it have to do the same for a man? Can it accommodate the woman but not the man? I think the evidence showed that the risks to the women were slightly greater because it's an ongoing. It's not like a one-shot proposition, but there was some controversy over the level of risk across sex in this case. So there you have it. It's a liberal feminist victory because women are the same as men and should be treated alike. Let me move on to a different area of the law, and I'm going to take these two cases together here, provide an overview. My slides, you know, they have too much text, but that may help you review and study, so I've decided to leave them with too much text. The next two cases, one we are getting in the form of a story, a chapter by Gillian Thomas in her recent book on Title VII and sex discrimination. And the book tells the story of 10 cases, and it's a fascinating book through time. And there's actually a chapter on forklift systems too. But the chapter I gave you is the Vinson case, which is the landmark case, right? And in the extra credit assignment, I've asked you to think about, wow, why does it take till 1986 for this idea to develop? And the idea is the behavior we now understand as sexual harassment, and we have that understanding particularly under the law, under civil law, it's not criminal law, in the workplace and at educational institutions. Is that behavior sex discrimination within the meaning of Title VII? Title VII doesn't say sexual harassment, it says sex discrimination. So is this a case of that? Right? And how does this become a case of that? So it's a recent development. Thomas's account, I think, is fascinating for the story of its origins and development. And it's an egregious case. This young woman, very young woman, no college, trying to work her way up at a bank, Michelle Vinson, is horribly harassed and horribly treated by a dictatorial supervisor at this small bank. He's an African American man, she's an African American woman, and he hires her and takes her under his wing, and then he starts demanding sex and really basically committing the forms of rape and abuse, constantly demeaning. He threatens her with violence if she ever, says anything to anybody. So this is her account. There's a fair amount of verification in terms of what other people saw and what he did with other people. I think it's interesting that Thomas sort of reveals that the federal district court judge, the trial judge who heard the case, um, had most of his background in criminal cases, and he sort of treats the defendant here and the individual involved as if he's a criminal defendant. So he rules out of bounds a lot of evidence that would inform, you know, um, a jury about his character and the plausibility of her claims. That he uses the rules of evidence to narrow the case down to he said, she said, and if he just flatly denies this ever happened and that she's crazy and she's fantasizing, it's hard to know. But a lot of evidence is excluded. And this is another legal studies point. There are rules of evidence in court, and generally the rules are supposed to rationalize the debate so that is the evidence relevant? Well, what he did with other employees may not be relevant to the question of what he did with this employee, but that makes more sense in a criminal law context where we're bending over backwards to protect the defendant. May make less sense in a civil law context where we're just talking about monetary damages. But that's what happens below, and there's a lot of skepticism about women and gender and power in the trial judge's handling of the case. There's discussion about how she dressed, discussion about some of her conversations with her coworkers. Another thing that's interesting about this story that Thomas tells, though, is a point I want to get to in just a second. But we're going to get to the point after 1993 where there are two kinds of sexual harassment claims. Sexual harassment itself has to be recognized as a form of sex discrimination, and that's a development of the law. And there are two kinds of cases. Quid pro quo is you do this or else, like you do what I want or there'll be a consequence. Or if you do this, there'll be a benefit, right? This for that, quid pro quo. That's a clearer violation. Sexual harassment or hostile working environment is less clear because we need to take account of a lot of things and make judgment calls about when an environment becomes illegal. And that's Vinson's case. It's a severe form of a hostile work environment. Now, Thomas doesn't use the phrase, but I want you to think about this phrase. This is a very interesting case of legal mobilization. And I've defined it here as a translation process, that the social realities and the facts and the concepts that come out of the culture have to be translated. They have to be reformulated in language and terms the legal system can legibly understand, right? Like, is this a case of that? So you're translating into legal terms to render it as a plausible legal claim. You've got to work with categories and you've got to work with facts, and you've got to do both of those things at once, right? But it also involves a material resource issue. You don't mobilize the law and change the law without money and power, because you have to work across a lot of different institutional settings. You have to bring a lot of cases for cases to bubble up. And the Thomas chapter does a very good job, because you were introduced early on to law professors who have institutes at their law schools. And Cornell Law School is not a minor institution, and they're working on it. They're thinking about it. They're reading, they're researching, they're writing. They're mobilizing the law that exists to make it mean something different than it means. And there's a fairly famous feminist theorist who's at the center of this effort. Her name was Catherine McKenna. She later became very controversial for arguing for pornography to be essentially banned in the mid 80s. But this is her best moment. There's a 1979 book on sexual harassment. So I mean, I think we could take this sort of framework about mobilization and apply it to a lot of different settings and how it works. Um, so what happens in the Vinson case is that she loses in the trial court. The next court, the Court of Appeals, simply affirms based on what the trial judge did. So she loses. And it is devastating. Another thing you get out of these chapters from Thomas is the cost to the individual plaintiffs, the people who are sort of heroic because they suffer, they lose their jobs, they have psychological trauma, they're attacked. And Vincent is sort of an interesting personality and character, and she stays with it. And when it goes up to the Supreme Court, they win. And the big win is that if an environment is severe and pervasive, then it does violate Title VII. That's the basic takeaway point of Vinson. You win. You can analogize from prior cases of a hostile racial environment. I mean, ideas don't come out of nowhere. There's a line of cases from the late 60s and early 70s that African Americans who face racial hostility at work constantly have a claim under Title VII. Well, why not sexual hostility? And violence in this case. So that's the win, but, and this isn't in the slides, the hanging term again that requires elaboration and development that isn't really defined in Vinson is severe and pervasive. How do we know an environment is hostile in a severe and pervasive way? How are we gonna know that? Aside from evidentiary problems. And that's what Harris v. Forklift is about. So I had you read this case. This is also an interesting story. Teresa Harris is also not someone who went to college, but she's charismatic and ends up being very good at sales. And she ends up getting involved in a male-dominated industry, the construction industry, but she's talented at what she does. And she works for this forklift systems company in Nashville, Tennessee. And she's very good at her job. She's very successful. What she does is she makes deals with other firms that are doing construction to rent the construction equipment, the cranes, the scaffolding that you need to do construction from Harris. She proved that her boss demeaned her sexually. This is not anything like what Vinson suffered. She's not touched. She's not raped. She's just demeaned. She's called the dumbass woman. Sexual jokes. When she gets a contract, the boss says, well, what did you perform sex? I'm not using the words he used, but did you perform sex to get the deal? He says these things in front of others. He drops coins in front of him and sort of orders her to pick them up. He's a jerk. And, he kind of admits he's a jerk. Like, he doesn't say I didn't do it. He says I did it, but, I was just fooling around, can't you take a joke kind of thing. The wrinkle in the case that's interesting, and this is in the case, is that she eventually takes it, she puts up with it because she needs the job for lots of reasons. And eventually she goes in with a tape recorder and she says, I want you to stop this. It's too much, it's ongoing, I can't do my job, and I want you to stop it. And she's performing her job very well, but when she goes home, she's suffering. She can't sleep, she's drinking too much, she's having a hard time dealing with this. And he says, well, all right, fine. I can't take a joke, but fine, I'll stop. But then he doesn't stop. He keeps doing it. And she resigns and she sues him, right? So what's the issue in the case? The case is really about what kind of verbal formulation we're going to use and how that matters, right? So the lower court says, this is objectionable. We don't want to condone this conduct, but does it rise to the level of sexual harassment? It isn't like Vinson. It's not as severe. So the lower court says, as a number of lower courts are saying, well, she didn't really suffer psychological harm, right? We're looking at her and how much damage did it cause to her? And, her job performance was always excellent. And yeah, she had some personal issues, but nobody ever found any trauma or psychological harm, and she couldn't really prove that. Well, the issue in the case is that the proper standard? Some lower courts said yes, and some lower courts had a different standard, which is, and we're going to transition into sexual violence in the law. Do you put the spotlight on the perpetrator or the victim? right? Here, we're looking at the victim and the impact of the behavior on the victim. Why don't we look at the behavior and ask a different question? Did it impact the work environment such that it made her more difficult, made it more difficult for her to do her job? Is she enduring something that men are not enduring based on her sex? That's sex discrimination, and we don't have to get to psychological harm or not. We don't have to ask that question, even though the lower courts thought that was the proper question. All right, and the court's unanimous in this case as well. And I think it's interesting in the Thomas chapter. At one point, the supervisor, a guy named Hardy, who met with Teresa Harris during the case, and they were ostensibly meeting to see whether they could settle, because he actually owns the company. And she expects there'll be some negotiation. And when she says, "Well, I'll settle for $25,000," it's not enough, but I'll take that. He gets very angry, right? And he starts being aggressive and abusive toward her again, and says, "I'll wear you out. I have money, you don't. I'll just wear you out in court." And she says to him, she reports that she says to him, "I'm going to take this case all the way to Sandra fucking Day O'Connor." And that's how she puts it to him, which is something I have to say that's admirable. And actually, Sandra effing Day O'Connor writes the opinion. O'Connor's, again, the first woman on the Supreme Court. And, O'Connor's a big fan of the totality of the circumstances. How are we going to know? Well, the psychological harm test is not the right test, right? It has to be one that a reasonable person, is the reasonable person male or female? It has to be one that a reasonable person would find to be hostile, right? It can't be a few jokes. It can't be a few off-color remarks. There has to be an objective component to it, not just her subjective experience of it, but you need both. Is it objectively hostile, and did she experience it as hostile? Not did she have a nervous breakdown? So she writes this line, right? Title VII comes into play before the harassing conduct leads to a nervous breakdown. Beautiful line. Does it interfere with the employee's job situation and performance, right? And how do we know? Well, how severe is it? How frequent is it? Is it accompanied by unwanted touching or suggestions or threats of violence or actual violence? It's 9-0. Scalia even votes in favor of this concept and this test. But, juries are going to decide, and he's a little worried about that, but he's not so worried that he's going to dissent. Ginsburg concurs, the late Ruth Bader Ginsburg, and she writes, as she characteristically does with great style and precision, there should not be a requirement of an actual showing of lower job performance. You don't have to show me that your performance declined. And in fact, Harris's job performance didn't really decline. You're just making it harder for her. And the making of it harder for her is because she's a woman and you're sexualizing your interactions with her in a demeaning and derogatory way. So this moves us on to sexual violence in the law. Sort of wrapping up, we've seen in this set of cases some resolutions of questions, but also lots of unresolved tensions between the way we're embodied, the way gender works, all pervasively, and law's effort to provide more reason, more equality, more fairness in this particular institutional setting. So I'm going to stop share, and I'm going to say goodbye, and I'll see you with the next topics for next week.